A few words about implementation then. As I'm sure you're all aware, but it probably bears repeating. Existing tenancies and licenses will convert automatically to become an occupation contract on the 1st of December. That doesn't include, I should say, old Rent Act tenancies. They're left alone. There aren't many of them left, but we didn't touch those. So the main message really is an assured short hold tenancy that will convert to a standard contract. If it's a fixed term AST, it will convert to a fixed term standard contract, periodic AST to a periodic standard contract. And then just in case, I think there are some still out there, so it's probably worth flagging this. If you have an assured tenancy in the private rented sector, that will convert to a standard contract, but it's a standard contract without the no fault notice ground, without the section 173 no fault ground. So essentially that gives us the similar level of security of tenure to a secure contract under the legislation. So for new contracts then from the 1st of December, the written statement, that statement of the contract, has to be given within 14 days of occupation. As I'm sure all of you will be issuing contracts in advance of someone moving in anyway, but so that's just a reminder. You need to make sure they have the contract within 14 days of occupation. If that's not done, then the tenant can start withholding a day's rent for up to 2 months' rent until that written statement is provided. So we have made those model written statements available at our website. Again, I'm sure many of you have all got online and found those, and maybe we'll have some questions about them afterwards. So that's new contracts, and so I always say to people, just make sure you do have that new contract in place from the 1st of December, because that does have to be given within that 14 days of the person moving into the property. So for existing tenancies, those ones that are going to convert, again, the written statement has to be given, but you've got 6 months to provide that written statement. So that doesn't have to be given until the 1st of June next year. So I think that's quite important for people to understand, that you've got some time to provide that written statement. The contract will change on the 1st of December. The contract will change in law on the 1st of December, but you've got 6 months to allow the paperwork to catch up with that change in law. I'm sure you're all aiming to get it done sooner than that, but that's the 6 months by which it has to be done by. And we have then produced guidance on converting a contract. So that is available at that link on our website. And that is based on a periodic standard contract, which will probably be the most common one that you'll be dealing with in terms of conversions. But again, it's going to be very similar from a fixed term basis. If we can move on to the next slide then, please. So this is just some key features of the Act, and I'll say a bit more about some of these later, but just to run through them, you've got the obligation on landlords to ensure the property is fit for human habitation. That is a different arrangement to the fitness for human habitation arrangements in England, but I'll say a bit more about that later. Again, there is provision in there to address retaliatory eviction. Again, it's not the same as is in place in England at the moment, so it is a different arrangement in Wales. There are more flexible arrangements for joint contracts, which means you can add and subtract tenants to the tenancy without ending one and starting another. There's an increased notice period for a rent increase, so that goes up from 1 month to 2 months. And there's no mandatory ground for eviction for serious rent arrears in the secure contract, but the secure contract is the default in the social rented sector. The mandatory ground for serious rent arrears does stay in the standard contract, which is the default in the private rented sector, and it's the same definition at the moment of 8 weeks, 2 months serious rent arrears, and as I say, it is a mandatory ground as well. There are enhanced succession rights. These are probably of less concern probably in the private rented sector. Of course, succession rights do apply at the moment to assured tenancies and assured short-hold tenancies. But I think essentially if a succession did take place in a in an AST at the moment, and the landlord wasn't happy with that, then they would obviously be able to end that AST at the moment using the no fault ground. And essentially the same arrangements will apply under renting homes. So a succession can take place. It might be a succession that the landlord is quite happy with, but if not, there is that no fault ground still available. The another key change is the repossession of abandoned dwellings. So we have made it easier to repossess abandoned dwellings, so the landlord doesn't have to go to court, which obviously can take some months, and get essentially at the moment a no fault possession order to repossess the property. And we have also made a tenure specific to supported accommodation. I won't dwell on that. So if we can move on to the next slide, please. So the other main change, I suppose, and this was done through the amending act that went through back in 2021. As you'll be aware, obviously, it's not unique to Wales. There's been quite a strong policy interest in increasing security of tenure within the private rented sector. Changes have been made elsewhere. I know Republic of Ireland made changes, Scotland have made changes, England's talking about making changes and bringing in their Renters Reform Act as a bill as well at some point. So the approach we took in Wales in terms of increasing security of tenure was, rather than abolish the no fault ground, which is a bit of a misnomer really, because the landlord will always need to be able to get possession back of their property, even though the tenant isn't at fault. So if they want to live in the property themselves, they want to sell the property or whatever. So we took the view in Wales, rather than abolish the equivalent of Section 21 in Wales and then have to replace it with a lot of other grounds for those other purposes, we just said, look, the landlord needs to be able to get possession back on a no fault basis, but if the tenant isn't at fault, they should be able to, the tenant should have 6 months to find somewhere else to live. So that's the core message really. We said, if a tenant isn't at fault, they should have 6 months to find somewhere else to live. And then we also introduced a restriction on issuing that no fault notice within the first 6 months of occupation. So that means essentially there's a minimum 1 year security of tenure for a tenant who doesn't breach the tenancy. There are some restrictions as well. So if, for example, a retaliatory eviction is found by the court to have taken place, then the landlord can't issue another 6 month notice until 6 months have elapsed from that court decision. So just to sort of make retaliatory eviction even less of something a landlord might consider doing. We also, of course, had to make some changes to how fixed term contracts worked. The main reason we had to do that, and I suppose first of all I should say, we did decide to keep fixed terms. We felt in Wales they can provide a useful purpose. So we kept fixed terms, but in order to ensure that security of tenure policy was maintained, we had to change how fixed terms can be ended, so that you can't basically have a succession of very short fixed terms, which would undermine that sort of security of tenure policy. So the change there is essentially you can have a fixed term and that can work, and if the tenant leaves at the end of the fixed term, great, that's it, it's worked as intended. But if the tenant overstays on the fixed term, and obviously quite often at the moment you do have an arrangement where a fixed term is issued for the first 6 months or a year, and then it's allowed to go periodic. Well, if that happens and it goes periodic, then you are in the situation of the landlord having to issue that 6 month no fault notice, assuming there's not a breach. So that's the change in terms of fixed terms. We kept them, but we had to tighten up really around how they could be ended. And we also had to make some changes to how break clauses operate. I don't think break clauses are a big feature in the private rented sector, but nevertheless they're possible, so we had to make some changes around that. And then of course recently we have consulted on applying that 6 month no fault notice period to existing tenancies. So if I can just move on to the next slide, please. So as you know, at the moment most private tenants will have an AST, and under that landlord can make a possession claim to the court after giving that 2-month notice if the tenant remains in occupation of the property, and they don't need to give a reason. So, hence the no fault ground. So for new contracts from the 1st of December, landlords will have to give that 6-month no fault notice under section 173. So that was always the case. The 6-month notice would apply to new contracts. But currently, for existing ASTs, a landlord will be able to issue a 2-month notice rather than a 6-month notice. So that's the law as it's currently drafted. So what the consultation proposed was to extend that 6-month no fault notice to existing tenancies from the 1st of June 2023. I should also flag, if a fixed term tenancy at the moment, a fixed term AST, if that converts to a fixed term standard contract, when that fixed term standard contract ends and a periodic replaces it, that would already be subject to the 6-month notice. So we're only talking here in terms of a change where you've got an existing periodic AST that will convert to a periodic standard contract. So we can move on to the next slide. So why did we consult on this? What's changed? Why did we want to do this? Well, obviously the overarching policy, as I said at the start, really was about increasing security of tenure. And one of the concerns really was, obviously, when implementation happens, those existing periodic ASTs will convert, and they would remain subject to a 2-month notice, perhaps for many years. I mean, I know the average length of tenancy. Well, I see different figures, but the average length I see somewhere between 2 years and 4 years. I think in the private rented sector. Interested in your thoughts on that. But actually, some ASTs continue for a lot longer. So what we didn't want was to have people for many years potentially subject to a 2-month no fault notice. And apart from anything else, obviously, as time goes on, the more difficult it is, or it might be to remember, now, did this contract start before the 1st of December or after the 1st of December? So it is also about sort of greater clarity of the law further down the line as well. So what does this do? Well, it will give more time for people to find a new and more suitable home if they are being evicted. So that goes back to this if someone's not at fault, we think it's reasonable that they should have 6 months to find somewhere else to live. It will, as part of that, reduce pressure on homelessness services and temporary accommodation. There's huge ongoing pressure there at the moment. Obviously, there's still a lot of people in temporary accommodation resulting from the COVID epidemic, and indeed increased pressure at the moment with people fleeing Ukraine and Afghanistan and Syria as well. So there is a lot of pressure on that temporary accommodation and on homelessness services. So really, by giving people 6 months notice, it does give people more time to sort their own, to find their own housing as well. Because we also looked at the experience during COVID, and we obviously, as we received many letters from landlords and indeed agents during that time, and a lot of people were concerned about tenants had stopped paying rent. Maybe they couldn't pay rent because of having lost jobs or whatever. And obviously during those COVID restrictions, we were applying a 6-month notice pretty much across the board. The only exception was really antisocial behaviour. So even if someone was in rent arrears, it was a 6-month notice that applied. So, but having said that, as far as a no-fault situation is concerned, I think that the sector managed that period, and I mean, I think it managed it very, very well, and I think that's due to a lot of tolerance of landlords in terms of where tenants are in rent arrears, and a lot of work by agents to support people through that period. But essentially, what we're now saying is actually the 6-month notice can work in that no fault situation, provided that there are those other shorter notice periods that apply for breach of contract. So under renting homes, a general sort of breach of contract is a 1 month notice period. That would include sort of minor rent arrears, if I can put it like that, something that doesn't meet the threshold for the serious rent arrears ground. There is the serious rent arrears ground, as I said earlier, which is a 14-day notice. And then in cases such as antisocial behaviour, the landlord can go to court on the same day that the notice is served. So those shorter, bearing in mind those shorter notice periods will apply, we felt that the 6 month can apply to the Section 173 on existing tenancies when they convert. And of course, the other thing we've seen are changes in the rental market. So more evidence of sort of increased amounts of rent in advance being sought, higher deposits being sought. So that longer notice period, if someone is being evicted, will allow the tenant more time to actually save for the move as well. So the consultation has closed on Monday. Thank you very much if you submitted a response to the consultation. My colleagues are currently reviewing those responses, and we'll be making an announcement shortly on the way forward as we see it on the back of those on those responses. So if we can move on to the next slide, please. So I said I'd say a bit more about some of the major changes in the legislation. Fitness for human habitation, that is a significant change. But it's based on the existing 29 hazards under what's called the Housing Health and Safety Rating System. That's the system that is used by local authorities when they enforce a sort of housing health and safety issues. And then there are the 3 specific requirements, which is the fitting of carbon monoxide detectors, hardwired smoke detectors, and electrical safety testing at least every 5 years. So fitness applies generally from the 1st of December to all contracts. So they all that obligation to ensure the property is fit for human habitation applies across the board from the 1st of December. But the requirements for hardwired smoke detectors and electrical safety testing won't apply until the 1st of December next year. So there's a year's grace basically in terms of having those hardwired smoke detectors and fitted and electrical safety testing carried out. The guidance on the fitness for human habitation, we are just making a slight tweak to that because we particularly had some comments back about why were we not allowing an electrical installation certificate to also satisfy the requirements for electrical safety. So we've engaged with the sector and we have identified really that if an electrical installation certificate has been given on a new build property within the previous 5 years, that will count as an electrical condition report under the regulations. So that tweak will be made to the guidance shortly, but I just wanted to make you aware of that this morning. And the guidance generally is available at that link on the page. So if we could go on to the next slide, please. And I'll say a bit about retaliatory evictions. So yeah, it's a different process to the system that some of you, if you work across the border as well, may be familiar with in England. Essentially, in Wales, I think it's a bit more straightforward. But if the landlord issues this no-fault notice under Section 173, or indeed a break clause if that was in place, and the tenant is able to provide evidence to the court that they had previously complained about a broken boiler or something of that nature, and then they were sort of hit after that with the no-fault notice, the court would be able to consider that evidence, and the court would be able to decide whether or not to make the possession order under Section 173. So it doesn't mean that if there's any evidence, the court would automatically disallow the possession order. It just allows the court to say, okay, we can see that this notice that the tenant asked for a repair on the Monday, and they were given the Section 173 notice. Sorry, they were given the no-fault notice on the Tuesday. Actually, we think as a court that looks like a retaliatory eviction. They might not think that if the request for repair was 6 months earlier, for example. But it basically allows the court to take a decision. And if the court is satisfied that the landlord was trying to avoid the obligations on fitness and repair, they can say not make the possession order, and the landlord is then restricted on issuing a further no fault notice for 6 months after that. If we can move to the next slide. And the other significant change I mentioned earlier is about abandonment. So this is where essentially the tenant has deserted the property, and at the moment the landlord will often end up having to go to court to get a possession order in order to have the sort of legal certainty that they've got possession back of the property. Under renting homes, we wanted to avoid, properties standing empty unnecessarily. Obviously, that's not a good use of the housing stock at the end of the day. So, if the landlord thinks the property has been abandoned, they can give a notice to the contract holder, which they can serve at the property or any other address they've got, saying they believe the property has been abandoned. That's a 4-week notice. During that period, the landlord must make inquiries to make sure they're as satisfied as they can be that the property has been abandoned. And if after those 4 weeks they remain of that view, they can serve another notice, and that ends the contract at that time. So that is quite I think a useful tool for landlords to have available to them. To use it, there does have to be a clause. You do have to have the term in the contract that says the tenant or the contract holder has to occupy the property as their only or principal home, because obviously if it's not their only home, then they might not have abandoned it. They might just be living somewhere else for the time being. So you do have to have that clause in the contract, but essentially I think it could be quite useful to the sector. But if within 6 months of recovery of possession, the contract holder turns up and wants to contest it, they can contest the abandonment. So that is there obviously to make sure that the procedure doesn't get abused, and because the court can make any order it thinks fit, if it found against the landlord in that case, it just underlines, make sure if it is being used that you're confident that the property has indeed been abandoned. Joint contracts. So again, a significant change really to how tenancies will operate in future. So at the moment, if you've got joint tenants and one joint tenant writes to say they're leaving, that will end the contract for everyone in the property, and that can cause a lot of uncertainty. It can cause unintentional homelessness, etc. So under renting homes, you can basically add a tenant to the tenancy without needing to start the whole thing again, but that is subject to the consent of the landlord. So if the landlord isn't happy with that change, then that can be prevented, and it also allows joint contract holders to leave the contract again. They will serve a notice, a withdrawal notice to withdraw from the contract. That isn't something that the landlord can stop, if you like. That is within the individual's choice as to whether or not they want to withdraw from the contract. I know some people have asked me, well, what about if that was the major breadwinner, if you like, the major earner who's leaving the contract? Well, yeah, that is possible that could be the case, but of course the remaining person themselves could then go and get work and continue paying the rent. So, so the whole point around joint contracts and having that new flexibility is to allow things to really reflect, I suppose, how people live their lives a bit more today, really, in terms of being a bit more fluid in that sense. So just a bit about sort of the regulations and the guidance. We've got on our website, and the link was earlier at the start of the presentation, all the regulations around fitness to human habitation. We've got the regulations on the model written statements and the terms of the contract. I haven't said today much about fundamental terms and supplementary terms, but I'm very happy to cover that in questions. But I think probably quite a lot of you have heard me say that some of that before. Then regulations around deposit schemes. Essentially, deposit schemes aren't really changing. So I mean that's very much as you're already familiar with, and we've had a lot of discussions with the deposit schemes and making sure that they're aware of the changes. And they're quite content really with how this is going to work. And if I move on to the final slide, the guidance. So again, a lot of guidance on the website. There's general guidance both for landlords and for tenants. We've got guidance on fitness human habitation for landlords. We've got guidance for tenants as well. Those written contract templates are there, and the guidance on converting a contract. If you haven't looked at that, do have a look at that, because I think that'd be quite useful to you. There are easy read guides for tenants as well, and we've got plain language guides to the contracts. I do recognise some of the wording in the contracts is, well, it is a legal document at the end of the day. It's got to stand up in court, so it does use words like repudiatory breach, but it needs to, because that means something to the court. But I say there are those plain language guides available as well for people to understand something if they need to. Okay, I think that's the final, well, just one final slide, just with my contact details again, but